Good afternoon, everyone. My name is Jae Kim. I'm leading Vira's New York bail reform evaluation study. And today, we at Vira, we conduct multiple research projects to understand how this bail reform in New York State is impacting the lives of the people in New York State. We conduct court observations to understand how the judges are implementing the bail reform. And then also we interview system actors, including prosecutors, defense attorneys, and also pretrial supervision officers to understand their perceived impact of the bail reform. And then the other thing is that we actually pay attention to incarceration trends to understand how this bail reform actually impacts the number of the people who are incarcerated in jail in New York State. So Division of Criminal Justice Services, or we call DCJS, provide multiple monthly jail population trends. And then here on the trend, you can see that in April 2019, about 21,000 people were incarcerated in jail statewide, and then majority of them were detained pre-trial. And then the jail population trend has overall downward trend, and then the largest decrease or substantial decrease happened in November 2019, which indicates that states and then counties started implementing the bail reform 2 months before the actual rollout of the bail reform. So in January 2020, about 15,000 people were incarcerated in jail. So about 6,000 less people are incarcerated in jail. And then obviously, as you all know, in March, COVID-19 pandemic hit. And then in July 2020, about 11,000 people were incarcerated in jail, statewide jails, which is only the half or 50% drop from the jail population in 2019. Unfortunately, this trend didn't persist. As you can see, in the latter half of 2020, the jail population started to go up. And we see the similar trends in both New York City and non-New York City counties. And then one thing that I wanted to mention here is that about 2/3 of the New York State jail population is actually coming from the non-New York City counties. So even though a lot of media attentions and conversation about incarceration trends in New York City, actually the New York jail incarceration trend is mainly driven by the non-New York City counties, and I think this is something that we should pay attention to when we are talking about the impact of the bail reform statewide. We also look at the changes in jail population by regions, and New York City as a reference, so about 37% of the jail population decreased from 2019 through by the end of 2020. And then you can see that Hudson Valley regions and Long Island regions, showed the largest, even greater decrease in jail population. More than 40% population has decreased in 2020. So the DCJS data provides the good overall snapshot of the jail population statewide. But for us to be able to understand what actually has changed after the bail reform, we need more granular and individual level data. And as you all know, New York City actually has a pretty robust jail data, and then also other types of the criminal justice data available through New York City Open Data Source. But we weren't, unfortunately, the rest of the counties, rest of the state, we do not have that data set. So what Vira did is actually we reached out to all 57 county sheriff's departments and asked them for the data. And we received the data from 49 county jails. which covers about 86% of the non-New York City jail population. And so including New York City jail data, it covers about 91% of the jail population. So understanding the full impact of the bail reform on jail incarceration takes time. And then in addition to that, pandemic happened. So what we can do in the meantime is just exploring the immediate impact of the bail reform by comparing the incarceration trends in 2019 comparing it to the incarceration trends in early 2020. So the graph in front of you shows the average monthly admissions by chart severity. And then here you can clearly see that more than 50% of the drop in jail monthly jail admissions in mainly misdemeanors and nonviolent felonies, but that drop is not as distinct and then not that much for the violent felony charges, which is understandable and expected given the bail reform legislation that was mainly targeted on the misdemeanors and non-felony charges. And we also see that the similar trends between non-New York City counties and New York City. We also looked at the likelihood of jail admissions after arrest, and then the finding is not surprising. We consistently see that more than 50% drop in the likelihood of jail admissions. But one thing that I wanted to address here is that depending on the regions of the arrests, so whether you are arrested in New York City versus whether you're arrested in counties outside of the New York City, your likelihood of pretrial detention after arrest varies substantially. So here, for nonviolent felony charges, for example, about slightly less than 50% of the nonviolent felony arrest resulted in pretrial admission in early 2020 in non-New York City counties. But compared to that, in New York City, only 11 or 12% of the nonviolent felony arrest results in pretrial detention or jail admission. So something that we have to pay attention to, these drastically different characteristics and the patterns in incarceration across New York. And then we're going to look at the changes in jail incarceration throughout the 2020, just to see the prolonged impact and effect of the bail reform, as well as impact of the COVID-19 pandemic. We just divided these 2-year time periods into five buckets or the 5 bars. And then when you just compare the black bar to the gray bar, this kind of shows that after the largest 50% decrease in jail population after the bail reform, there was another 50% decrease in jail population after the onset of the pandemic, and then you see that the admission kind of goes up in the latter half of the 2020, but it kind of never surfaced the level of early 2020 jail admissions. And this is the result for the non-New York City counties, and then the other is, and then we see the same trend in New York City as well. So last point that I wanted to make here is that, understanding, whether, exploring whether this bail reform actually has changed the racial disparities, the existing racial disparities in the system, and particularly in incarceration. Because one of the, consistent research findings in the criminal legal research is that Black and brown people are disproportionately more likely to be incarcerated in jails, and then we were curious to know, whether bail reform actually, contributed to the decrease in this existing racial disparities. And then, unfortunately, what we find is that overall, the fewer number of Black and brown people, and also fewer number of white people were incarcerated in jail after bail reform. Actually, the ratio of Black to non-Latinx white incarceration rate increased after bail reform. So in 2019, Black people were 5 times more likely to be incarcerated to jails compared to non-Latinx white people, and then this difference increased to 6 times by the end of the 2020, which is something that we should pay attention to as we are exploring the long-term impact of the bail reform and the pandemic. So just to summarize our research findings, the jail population decreased more than 30% from April 2019 to March 2020 in both non-New York City counties and New York City. And the likelihood of pretrial detention after arrest decreased by almost 50% for misdemeanors and non-violent felonies. Still, more than 13,000 people are incarcerated in jails, mostly for pretrial detention in December 2020. And also, when I checked the DCJS website, last month, about 15,000 people were incarcerated in jail statewide. And then lastly, the overall number of Black and non-Latinx incarceration decreased, but racial disparities persisted and have some evidence that it might have been widened. I want to end my presentation by introducing two VERA's two jail dashboards, and one of them is something that Aubrey already introduced, so thanks, Aubrey. Then the second jail dashboard that I wanted to introduce is that, this jail visualization tool shows the number of the people in jail across New York State from 2018 to 2020, and it's updated every 6 months, and then it has more granular information about the people who are incarcerated in jails, including bails amount, and then length of stay, and then racial disparities, etc. So for those of you who are interested in looking deeper on this incarceration trends, please visit VERA's website to check out this jail dashboards. That's it for today. Thank you.
Hi, everyone. I'm Jen Ferrone. I'm from the CUNY Institute for State and Local Governance. Thanks. And so some of my colleagues here presented data on outcomes since implementation of the legislation, and I'm here to talk about a process evaluation that ISLG is conducting around implementation of the reforms, and this is funded by Arnold Ventures. Oh, I went the wrong way. So to just share some important context just about this study before I dive into the findings, our goal here was to really document the process of implementing. This is a sweeping set of reforms, not only focused on bail, but as a number of the morning panelists talked about discovery, there were also many changes to appearance tickets, or called desk appearance tickets, here in New York City. So there were a lot, and of course pretrial service ramifications as well. So there was a lot going on. And ISLG chose to focus actually on desk appearance tickets and discovery in particular in our implementation efforts. But given our conversation here, we wanted to share what we've been hearing from stakeholders about pretrial services and bail in particular. So the goals of our evaluation was really to explore the ways in which New York counties and criminal legal system agencies across the state adopted the legislative requirements. And this is really, a lot about how they operationalize those in practice. As a lot of the morning panelists talked about, the legislation was often vague in certain respects. And so really, what does that mean on the ground for the stakeholders and practitioners that ultimately have to implement it? And with that, documenting the successes and the challenges that these agencies and individuals faced, and also to extract larger lessons learned from New York's experience, and really thinking about New York as a model for other jurisdictions, because as Sandra noted, this is taking effect in many states across the United States. Many states across the country. So in terms of our data, we participated in a lot of interviews in multiple New York counties, not just New York City, and really talked with various agencies from law enforcement to pretrial services to probation departments that ran pretrial services to public defenders, and also individuals that were impacted by the criminal legal system as well. I do want to note that we did not talk to judges because the Office of Court Administration was not able to participate in the evaluation, so anything talked about judges is really the perspective of the other stakeholders that we talked to. We also supplemented that with document and data reviews as we had available. So I was going to start here with some of the key findings around pretrial services in particular. And really this echoes a lot of what, Aubrey talked about in terms of pretrial services. And we're going to highlight a lot of the challenges, especially in the early days. This is an ongoing evaluation. So we are talking to stakeholders again about what's been happening, since the last time that we talked to them. But I do want to recognize that with all of the challenges that agencies have faced, they've done a tremendous amount of work implementing these changes. So I just wanted to note that before I dive right in with some of the negative things that we might have heard from people. So in terms of pretrial services, I think, a common theme across our process evaluation to date has been this kind of difference between New York City counties and counties outside of New York City. And this was very much exemplified when we were talking about pretrial service providers. This was an unfunded mandate. There were no additional funds available to counties in implementing this. And this was really felt by pretrial service providers, especially outside of the city, because a lot of them did have more limited infrastructures, did have more limited staffing structures, and so it was not as easy for them to implement some of the changes that were specified in the legislation. New York City, on the other hand, had already been engaged in this effort for a long time, as we heard. They had the resources available to them. And while they did experience a lot of challenges in kind of re-envisioning what their programs looked like, they didn't necessarily have the same challenges that those outside of the counties expressed in terms of their infrastructure, for example. Oops, keep going the other way. The second finding around pretrial service providers was really that there were a lot of uncertain expectations, and they felt that there was limited guidance provided to them by the state. And some of these expectations they felt were unrealistic, just given, again, their more limited infrastructure, the fact that there was not a lot of funding available to them to implement these changes. They did recognize NIAPSA as coordinating a lot of these efforts for them, though NIAPSA is not a state agency and it doesn't have any regulatory authority over pretrial service agencies. So while they felt that coordination provided by NIAPSA was helpful, they would have liked more and they craved more from the state itself. A common theme also coming out of our interviews was a lot of provider uncertainty about what to expect in terms of their populations, especially outside of the city. I think the city expected an influx of clients into their services, but providers in other counties across the state didn't know how the judges would necessarily interpret key aspects of the legislation and thought maybe there would be a lot of release on your own recognizance and not many referrals to supervised release, for example. And so it was very hard for them to tell exactly what they should plan for and what kind of client, what volume of clients they should expect in this instance. I have a lot going on here. So finally, in terms of trial providers, and Aubrey talked a lot about this, there was, adjusting to working with a different clientele. So there was this idea of an evolving target population, especially in the city, clients with more extensive criminal histories, clients that had greater needs, particularly in terms of mental health and addiction, and also clients charged with more violent offenses. And so this required really a new staffing structure. There was a big hiring effort in the city, and different staffing, different specialized qualifications. I also wanted to note here that there were concerns around net widening with respect to supervised release, and this was related a lot to those that were issued desk appearance tickets. Some providers expressed that they were seeing individuals with desk appearance tickets in their programs, which they hadn't seen before. And so this was a concern just given, are the resources being allocated appropriately for that population. So I did want to make that point as well. So in terms of bail and pretrial detention findings, and I'll go quick, I know I only have a few minutes, and I think, again, we heard this throughout the morning, and, Aubrey said it also, but participants largely subscribe to the spirit of the legislation. So the stakeholders that we interviewed in terms of law enforcement, prosecution, pretrial service providers, defense attorneys, they all subscribe to the goals and objectives of the legislation. They understood, what the legislation was meant to do. Though some of those stakeholders did feel that the pendulum may have swung too far in limiting discretion. And again, we heard that, I think, throughout the morning. That said, I did want to highlight a lot of the positive, aspects of bail reform and what public defenders and those impacted by the system told us when discussing the bail reform provisions in terms of it really leveling the playing field. And this is not something, again, that we hear a lot in the stories around bail reform, so I did want to highlight it here. Not only does it remove the economic barriers to release, but it also reduces the collateral consequences that individuals face that are coming through the system. They're able to be in the community. They're able to stay with their families, remain in, their ties to their employment and their community at large. They also have better case outcomes, as was discussed, so less harsh sentences. And also, there was a lot of discussion around plea negotiations as well. It removes the leverage in terms of that prosecutors have when someone is in detention during the plea negotiation process. And together with the discovery provisions, really allows an individual to think about the plea deal before they actually take it. And I'll talk about reducing racial and economic disparities in just a second. And then on the other hand, law enforcement and prosecutors definitely shared with us the perceived negative impact on community safety. Of course, this is a very, important issue and something that we're faced with every day, and what we're hearing in terms of the current trends. People felt that bail reform took the tools away from them in terms of being able to consider other things, and especially when it comes to those who they felt were cycling through the system multiple times. And, we see this reflected, I think we see those concerns reflected in some of the amendments to the reforms. But of course, it's a nuanced conversation and there's a lot to unpack there. So finally, with respect to bail reform, and I don't think this is a surprise, there were challenges securing buy-in, for the reforms across stakeholders. And I think, what we heard from law enforcement and prosecution in particular is that there was really, no victim's perspective in the way that the legislation was drafted and perhaps passed, and no voice at the drafting table for law enforcement and prosecutors. And so they definitely expressed that to us in our interviews. Also, I think any agency outside of the city really felt like a lot of the legislation was New York City centric. So a lot of the examples that were used in the legislation to ground the legislation were not necessarily applicable in an out-of-city context. And one example is just some of the logistical concerns around town and village courts, which often don't meet regularly. And so some of the timeline, implications weren't able to be addressed in those courts because they didn't meet regularly. That's just one example. And then just other implementation issues that we heard about was around the ambiguous statute language, which I talked about before, but certainly permeated throughout all provisions of the legislation. Issues with the charge eligibility, I think I heard it referred to as the bail bucket. So what is in that bail bucket versus out of the bail bucket on both sides? There were concerns perhaps it was too expansive, perhaps it was too restrictive. And there's also a lot of unintended consequences, that we might have to consider as well. And we've been hearing about some of, how would judges interpret certain pieces of the legislation in the courtroom. And then, finally, just this need for a culture shift. A lot of the agencies we talked to, talked about preparing for bail reform throughout 2019 so that they were ready on January 1st, 2020, though not all counties were able to prepare in that way. But, in order to make implementation a success, that culture shift really does need to happen. So finally, just wanted to end on, a quick note around eliminating racial and ethnic disparities. I think my colleagues kind of have already covered this on the stage, but something that did come out of our conversations with stakeholders was that this is definitely a recognized goal of the legislation. However, there really were they weren't necessarily intentional around disparities in the way that they planned for implementation of the legislation. And so we're not really seeing those impacts on the ground. As Jayok mentioned, we're actually seeing disparities increase at this time. So even though, some well-intentioned reforms Even though reforms are sometimes well-intentioned, they may actually exacerbate disparities. And I would urge stakeholders to consider ways that they might intentionally focus on disparities. And I think a lot of the charge-based decisions are probably driving some of that as well, because we know certain communities and charging practices are, centered on certain communities or disproportionately impact certain communities. And then finally, COVID was a whirlwind. Doing a process evaluation 2 months into our interviews, COVID happened. It shut down everything. And of course, it compounded implementation challenges. Courts just weren't in session. Timelines weren't in effect. So in order to get people to reflect on how things actually would have changed was difficult because it just wasn't the regular state of affairs at that time. So we're learning more now in our more recent conversations. So I'll end there. Thanks so much.
I want to digest a little bit of what I've heard first. I think we heard from Sandra about the research nationally, which mirrored the debate that we heard in the plenary session earlier. Yet, at the end of the day, what I heard was there's not evidence of a relationship between bail reform and crime. But then I think we also heard from Aubrey that it's a little more complicated. That doesn't mean nobody is rearrested, because there are rearrests. There were rearrests before bail reform and after bail reform. I want to cut to a few additional takeaways from what we heard next from Olive, Jayoke, and Jennifer. Number one, bail reform achieved one of its goals, which is to increase pretrial release. I think we heard that clearly. But then we heard about some of the goals that don't appear to have quite been achieved. We heard that bail posting of people who face bail has not improved. In other words, even though I started at the outset with having to take ability to pay into account being a core element of bail reform, it doesn't appear that we are there yet. And then we heard from Jayoke that while the use of bail, while jail populations pretrial have not gotten back up to where they were in 2019, her data shows that there was somewhat of a reversal, and there was somewhat higher bail setting towards the end of 2020 than at the beginning. And then finally, we heard from a number of speakers that although reducing racial disparities was a critical goal of bail reform, it doesn't appear to have been consistently realized nationally. I think that's a point, Sandra, that you had observed. And then we had seen this in New York. And then finally, Jennifer indicated that in her process interviews, it appeared as though people weren't focused on it or weren't sure how to achieve it. So I want to just sort of flag those as conclusions reached and issues raised here. And then I want someone in the audience here to ask a question. So who's going to do it?
Hi, so I have a question about data on and making assessments about the different kinds of release conditions. Do we have any data on that? If we don't, what do we need to get it? And basically, I'm asking because I'm a defender in Queens. How do I argue to a judge, or how do I and the DA argue over what the least restrictive means truly is, other than a judge's gut feeling about what to do?
Well, if you want data, we got it. So I would say go to the dashboard. I didn't show you as much of the New York City arrests filed with the court dashboard, which looks at, in any given month, the total number of cases heard by the court and the release conditions for that court. But specifically for your question, I mean, we provide not just supervised release in Queens, but we, as you know, we conduct a release assessment, which provides information to the court about the likelihood of return to court. And that release assessment relates to the recommendations of the intensity of supervised release, if that is so chosen. So there are, in fact, tools in court that I know you well know can be used, that some judges are more receptive than others. But I think there is an argument that can be made about the value of someone who has, say, a perfect score on a release assessment. If they're released, they're going overwhelmingly likely to return for all their court dates.
So I'll just speak to the non-New York City data. We do have that data. The data that we have allows us to kind of distinguish the different types of non-monetary conditions. We didn't do it for this report because if you look at the report, it's very long. But just to plug our work, our forthcoming kind of update on the first 2 years post-reform will dive deeper into the different conditions of release. So, yeah.
Just to add what Olive just said, VOA Institute of Justice also conducted analyzed the pretrial supervision data. We received the data from 5 counties outside of the New York, so Albany, Broome, Erie, Tompkins, and actually it's 4 Ulster counties. So like we received the data from those 4 county probation departments, and then and also we conducted core observations, and then we see that the judges are setting these conditions of release. But like what we see from counties outside of New York City is very much very much different from what we see in New York City context. So for example, there is not much of the variation in terms of the different conditions that's imposed by the judges. And then the second is that, I think this is something that Jen kind of touched on it, there are concerns about net widening of the use of the pretrial supervision services, but actually the data shows that actually that's not the case, because the judges that are judges who were typically setting pretrial release were prior to bail reform were setting conditions of release on the charges that are no longer eligible for bail. So actually it's just a mandatory release, and then the judges stopped kind of utilizing this setting pretrial supervision services in that sense. So so that's the findings, and then we also have the report coming up in a month or 2, so yeah, stay tuned.
I'll try to be quick. In the Harris County context, and this is a slightly different kind of response to your question, judges actually needed training around how to think about the different restrictions, and they were also provided on a fairly regular basis, like it is a pilot study, fairly regular basis, the impact of different kinds of restrictions, so that they would come to feel comfortable doing the least restrictive because they understood that it wasn't producing harms. And so so what was required above and beyond just saying do the least, judges actually need feedback about what that looks like and under what conditions, and also constant feedback about what the decisions are doing with regards to the people that their rulings impact. And I think that has to be an important part of this conversation because it matters.
Can I just add one more, the last thing related to that? So when we conducted core observations in Erie and Broome County, and then we actually saw that how the judges are setting bail, and like what kind of arguments are made or not made, and then what kind of arguments are made by the prosecutors and the defense attorneys. And then our research finding shows that actually 85% of the cases where bail was set, there's no discussion and then arguments about consideration about person's financial ability to pay, and also judges typically don't explain what the least restrictive means for this particular case or for particular defendants, and then typically their decision is mainly based on the charge severities and then also the other safety concerns or dangerousness. I think it's a kind of hard touchy topic to mention about it, but we already know that that's what's happening in the courtrooms, and then that's what the general practice has been like, by the judges.
I don't know if it's going to be an easy answer, but I know it was thrown out earlier, at least some statistics about like black on black crime being the reason why the system disproportionately targets black and brown people and why we find them in our jails. And so my question is really, and I've seen some of the research saying that the disparities still exist, and that in particular for felonies, white defendants are getting out on lesser bail or no bail compared to black and brown people. So as researchers, I'd like to know, how do you combat this black on black phenomenon, that's the reason why we have disparities in our system?
So some disparities are associated with higher rates of crime in Black and Latino communities. But almost, if we were to examine every stage of criminal case processing, there's evidence to indicate that bias also drives what happens in terms of creating these disparities. So it's not just about the fact that these communities are, and we should ask questions like when it's reported that folks from some communities are more likely to be rearrested after having an experience with the criminal legal system. I think we should be asking ourselves why that is the case. Some communities are over-policed and underprotected. And so of course, if there's a higher concentration of police in my communities that research shows is above and beyond the rates of crime that exist in those communities, then you should expect that there's going to be higher rates of arrest. And being arrested doesn't mean you committed a crime. Is an accusation. And part of what we're supposed to be here to talk about is the presumption of innocence and how you're supposed to deal with people who are presumed to be innocent. In a context where we know that there are serious issues with how law enforcement behaves, misconduct throughout the process, and that impacts disproportionately people of color and people from low income and poor communities. So I think all of those factors should be taken into consideration. When we think about higher rates of crime in some communities, I think we should also be thinking about other factors that drive it. Social dislocation, economic dislocation, where we're funneling tons of resources into law enforcement. We're not investing in those communities with regards to healthcare, with regards to education, with regards to parks and recreation, which we know dramatically reduces rates of violence and other kinds of crime. We're not investing in housing so that people are housing stable, in food, right? So if we were to shift our thinking about what is driving these factors and take seriously the role that bias does play in each stage of the process, I think that we can come up with different solutions.
Okay, we got to get everything for once. Yeah, we have the creator of New York City Supervised Release Program here. She raised her hand. Okay, Miriam, make a comment, anything you've got, ask a question, let's get a quick answer.
Okay, I'll make this very quick. So, Professor Smith, thank you so much for your work. I think, especially right now, really taking the conversation around bail reform away from anecdotes and away from sensational press has never been more important. My question on your data, in terms of, each of those states, their reforms happen in a slightly different time and, over time. And with New York, obviously, the big question, it happened at a time when it's just so hard to have an experiment because so many factors were thrown up into the air, including the time between hearings, the people being able to get to court and to have their hearings, and police enforcement changed during that time. I mean, so many things happened, and I'm curious if there's a way to pull apart the effects and be able to say, with crime and with hearing times, with trial length.
I think, thank you so much for the question, and I'd be interested in others' response to the question as well. I think it really is hard to pull out the effect of COVID. COVID just disrupted everything, so how do you address the impact? With regards to the question of bail reform, one of the important points I think both Olive and Jill mentioned in their talks was that jail populations were declining significantly in New York well before bail reform and COVID, right? And we saw with those declining rates of crime as well, right? It declined and then it leveled off. There was a point, I think probably 2019 or so, where we start to see upticks of something. But even if we focused on the New York context and went before COVID, we see dramatically declining rates of jail detention associated with, I'm not saying causal, associated with also declining rates of crime. It wasn't driving it up. Right? And we see other contexts. Look across the river, to New Jersey that implemented reforms in 2014, or at least they started to, right? In multiple reforms, including bail reform, we saw dramatically declining rates of jail populations not associated with. So it is the case that reforms happen across the country in multiple contexts much earlier, but most of those reforms have taken place since 2015 or so. Right? and before COVID. And if you look in those contexts, we're seeing very similar patterns. And I think that, so if we were all over the place, I think we'd have a question about, okay, what's really happening here? But generally speaking, the patterns are all in very similar directions, even in including racial impact on racial disparities. So I take that very seriously. And the final thing I want to say is, not only has the evidence shown with these rigorous studies done by folks like my colleague at Harvard, Will Dobby and his colleagues, showing that pretrial detention, not only does bail reform, this is what I want to say. I've shared that that most of the studies are showing that pretrial bail reform has the impact of, it does not drive up crime. This is what I want to say. Pretrial detention does. You increase the likelihood that someone will have future criminal legal system involvement if they have been detained, both at case disposition and 3 years after. So we know that detention does produce these poor outcomes that we're concerned about. And we're not finding evidence that bail reform, which reduces jail populations, does the same. That to me it's pretty, we should always look at nuance. I'm a sociologist, we get accused of too much nuance. But what we're seeing in terms of these patterns seems to be very clear to me.